Let's talk about our legal accountability. A paramedic, you are required to provide a level of care that your patients is consistent with your education and training, as well as equal to that to other paramedics with equivalent training. You're expected to perform duties within a reasonable and prudent manner. As any paramedic would in a similar situation, any deviation from this standard might open you up to allegations of negligence and liability resulting in a lawsuit, or any resulting damages. Most civil claims against EMS providers center around claims for negligence. Some are based on intentional tort. So, an intentional tort is a civil wrong committed by one person against another based on a willful act. Most forms of immunity do not provide protection when the claim is based on an intentional tort. So, negligence, as defined, is deviation from accepted standards of care recognized by law for protection of others against unreasonable risk or harm. It can result in legal accountability and liability in the health and in the healthcare professions. Negligence is synonymous with malpractice. Now, there's four things that need to be. There's four elements to negligence. They are duty to act, a breach of that duty to act. There has to be actual damages, and a proximate cause. The first thing that has to happen. Well, we can look at our liability claims. These are of 275 liability claims for a large national EMS insurer for a 2.5 or a 2 year period. And patient handling is 45% of the claims. So your handling of the patient, whether it be lifting and moving or positioning or you name it, anything to do with the handling of the patient, that's 45% of the malpractice claims or liability claims. Next up is emergency vehicle movement or collision, so actually driving. Medical management is 11%. EMS response or transport is 8%. Lack of or failure of equipment, 4%, and 9% of other causes rounding out the top end. So the first, the plaintiff has to establish that the paramedic had a duty to act. He must prove the paramedic had a formal contractual legal obligation to provide care. In some states, if an off-duty paramedic witnesses a person choking, he may be under no legal duty to act. However, if that paramedic initiates care, then he has a duty to continue care. The rationale behind this rule is that if bystanders see a victim is being helped, they may walk away. If the paramedic rendering assistance walks away after initiating treatment but not completing it, then the patient may actually be left in worse condition than if the paramedic never tried to help. Duties that are expected of the paramedic include the initial duty to act. Within that is a duty to respond to the scene and render care to ill or injured patients, duty to obey federal, state, and local laws or regulations, and a duty to operate emergency vehicles reasonably and prudently with due regard. Duty to provide care and transportation to expected standard of care, and a duty to provide care and transportation consistent with the scope of practice and local medical protocols. All this we know. All this we do on a general basis. There is also a duty to continue care and transportation through to appropriate conclusions. Meaning we take the patient, we continue our treatment all the way through the transport, and where we take them to is capable of giving them the treatment that they need or is the closest appropriate facility. We've discussed this. We only have one choice of hospital to get them to, but that is a higher level of care than we can provide in the back of the ambulance. A breach of that duty are three different types of breaches. A paramedic must always exercise the degree of care, skill, and judgment that would be expected under like circumstances by a similarly trained, reasonable paramedic in the same community. So you're going to be judged against your peers, what they would have done in the same instance. That is why we should talk to our crews, to each other, and base our QA/QI off of each other. The standard of care specific to the paramedics practice is generally established by court testimony and referenced published codes, standards, criteria, and guidelines applicable to the situation. So the state's regulatory regulations, your services protocols will be entered into as evidence and may be used against you depending on what you're accused of, or it may help you. And knowing what those protocols are and working within them is of utmost importance. In a civil lawsuit, the trier of the fact, most often the jury, decides the standard of care is. So we need to lay it out to them, or what needs to be laid out to them as clearly as possible. A breach of duty may occur by malfeasance, misfeasance, or nonfeasance, and they are defined as the following. Malfeasance is performance of wrongful or unlawful act by a paramedic. So you did something completely wrong, or you acted outside of your scope of practice or outside of your protocols. Misfeasance, performance of a legal act in a manner harmful or injurious. You provided care well within your scope of practice, well within your protocols, however, you applied it incorrectly and in an improper way. And nonfeasance is failure to perform required act or duty. You just didn't do anything. And by that act, the condition of the patient deteriorated. Res ipsa liquitur. The complainant must prove damages would not have occurred in the absence of somebody's negligence. So they have to prove that this is directly related to what you did and that you or didn't do and you being there. The instruments causing the damages were completely under your control at all times, and the patient did nothing to contribute to his own injury. Negligence per se is the paramedic violates the statute and an injury to the plaintiff results. So that kind of falls under you acted, but you violated but you acted outside of your scope. You acted outside of the statutes. Actual damages are defined as the plaintiff must prove he was actually harmed in a way that can be compensated by award of damages. So he was harmed in a way that caused him increased medical bills. He was harmed in a way that also caused him loss of work, so loss of wages. All those things must be proven as well, and that he can be compensated then by an award of damages. Not only can they ask for the damages, they can also ask for a punitive damages. They can also ask for extra money as a punishment towards you. Proximate cause is an action or inaction of the paramedic immediately caused or worsened the damage suffered by the plaintiff. The plaintiff needs to prove that damage to the patient was reasonably foreseeable, that you knew that this damage would happen if you did or did not do whatever action it was. Some of our defenses to negligence are the Good Samaritan law. If a paramedic can establish his actions were protected by a Good Samaritan law, liability may be avoided. Note that such laws generally do not protect providers from acts of gross negligence, reckless disregard, or willful or wanton conduct, such as an intentional court, and they do not prohibit filing of lawsuits. They can still file a lawsuit, but this is a defense against negligence. The governmental immunity. These laws do not offer much protection to the individual paramedic accused of negligence. The breadth of the governmental immunity established varies from state to state. In Kansas, I'm not sure what we have here as far as governmental immunity goes. I think those generally apply more as a broad spectrum over services. There's always the statute of limitations. There's a time period in which the actions can be filed or claimed. And then contributory or comparative negligence. Some state laws will reduce or eliminate a plaintiff's award of damages if the plaintiff is found to have caused or worsened his own injury. So if there was anything that they did that may have worsened or caused the injury in the first place, once you started care, then it pulls a lot of that liability away from you. For an example, a patient involved in a car crash complains of neck pain, but refused to let the paramedics properly immobilize his spine. So not allowing us to put him in a C-collar and follow protocols, they absolutely refuse. And we, in good faith, warned them the possible damages, the possible further injury that could come from that, and they still ignored it, and they did not allow us to do it. So, and they signed the release from liability form, but later they have permanent spinal cord damage and they try to sue for negligence. You're protected. Also, your documentation is going to protect you. Excuse me. In that instance as well. Other things to protect us against claims of negligence is we should be getting appropriate education, appropriate training, and continuing education. Appropriate medical direction, meaning our medical directors are involved and they are out there and they are training us and looking for deficiencies in education or refreshing where we need to be refreshed, that kind of thing. Accurate and thorough documentation is probably absolutely one of the most important things that we could do for ourselves. Accurate and thorough documentation, I cannot define that enough, that we chart exactly what happened as accurate as possible and as thoroughly as possible. Will save us from more lawsuit than anything. Maintain a professional attitude and demeanor. No matter what's going on, always stay professional and always maintain a level, even keel. Oh, sorry about that. Always act in good faith and advocate for the patient, even to the patient themselves. Use good common sense. I know it's very rare, but find it and use it. And being covered by medical liability insurance, basically covering ourselves with a malpractice insurance coverage. Liability insurance contains a duty to defend clause that provides the insured party with legal counsel to represent them during litigation. Although many agencies have liability insurance that covers their employees, there are two drawbacks to relying on it. First, your agency's coverage may be inadequate. Additionally, you and your employer may not have the same interests. For those reasons, paramedics should consider obtaining their own liability insurance coverage. So, that statement of your employer and you may not have the same interests. Our employer is going to look out for them. There's always another paramedic to take the job. So they're going to cut their losses and they're going to take care of themselves before they take care of you. If their insurance is being paid, if your medical liability insurance is being paid by your employer, that insurance is going to follow what the employer wants to do, not necessarily what you want to do. So it is a good idea to have a backup coverage of your own. So some of our special liability concerns is our medical director. There are several, but medical director is the top. If we make a mistake in the field and is sued by the injured patient, it is possible the patient will also sue the medical director. and the online physician. The online physician may be liable to a patient for giving the paramedic medically incorrect orders or advice, or the refusal to authorize the administration of a medically necessary medication, or for directing the ambulance to take the patient to an inappropriate medical facility. We need to protect ourselves, but we also need to we should be protecting our medical directors at the same time, and our online medical control. We need to give them the most accurate, concise information that we can give about the patient. We are their eyes and ears. So if something happens, we need to look at ourselves and what we did as well. The medical director may also be liable to the patient for negligent supervision of the paramedic. If the patient were to be successful in this type of claim, he would prove that the physician breached a duty to supervise the paramedic, and that breach was the proximate cause for the patient's injuries. Examples would be the medical director's failure to establish medication protocols or standing orders consistent with the current standards of medical practice for the paramedic to use in the field. So if you've got an old school doc that's not keeping up with the times and the standard of care, he may be setting himself up for being liable for damages. The medical director observing but failing to correct a paramedic's poor intubation technique, or the medical director receiving complaints of inappropriate care by a paramedic and then failing to effectively investigate and resolve the problem. So if he's getting consistent reports of a patient or a paramedic's inability or to take care of this patient, or take care of patients appropriately, then he would be liable. He can be liable for not correcting and or limiting that paramedic's abilities or scope. Under the borrowed servant doctrine, it's pretty similar, except it applies to us as ALS providers supervising BLS providers. Depending on the amount of supervision that we have, like if they are our partner, we are a direct supervisor of them. So that is something that we need to keep abreast of too, is to make sure that our partners are performing to the way that we want them to, and to be sure that the way we want them to is consistent with current standard of care for that level. Civil rights violations. In addition for suing for negligence, they may be able to sue for violating a patient's civil rights. If we rendered care for a discriminatory, failed to render care for a discriminatory reason, we can be sued for civil rights violations. We are not withholding care for any reason. If somebody calls us, we give them the care that they consent to receiving. Again, it falls back under documentation as well. Patients should be provided with appropriate care regardless of their status, condition, or disease, as well as race, creed, color, gender, sexual orientation, national origin, or ability to pay. We don't make those decisions. We don't get to make those decisions. We don't care about that. Our goal and our priority is to deliver patient care. Airway issues. Failure to secure an airway or failure to recognize an airway is improperly placed, resulting in devastating or fatal injuries to the patient. Failure to realize that we intubated the esophagus and missed the trachea. Failure to correct a correctable injury or illness. Failure to deliver a treatment. Numerous lawsuits and settlements have been filed related to an airway management, especially failure to recognize an endotracheal tube has been improperly placed. That is the worst one. We cling to intubation as one of the things that we can do, and people shove that into the nurses' faces and stuff like that. I disagree with that. However, a lot of paramedics do. Well, at least we can intubate. Well, unless we fix ourselves, we will lose that. And that is one of the biggest ones, is our egos are so big that we refuse to admit that we did not intubate properly. And we continue with a bad tube, and a patient dies or suffers a devastating anoxic event and is now no longer the same. All because we refuse to believe that we could miss an intubation. Paramedics know that intubation is a high-risk procedure, and to ensure that it is performed properly, that placement is verified by objective measures, capnography, colorimetric, direct visualization of the vocal cords and the tube passing between them, use of it's the turkey baster. I can't remember what the name of it is. It's not very accurate though. I personally don't like them. But capnography, direct visualization, and colorimetric end-tidal CO2 detectors are the standard, and then properly documented. Next to last is the patient restraints or restraint issues. A patient who must be physically or chemically restrained due to the patient's behavior. Chemical restraint and physical restraint are very, very dangerous, especially in my opinion anyway. You'll eventually encounter a patient who must be physically or chemically restrained because the patient's behavior is a direct threat to you, their own health, or the health and safety of others. The cause may be a medical condition, a psychiatric condition, or substance abuse, or any combination of the above. We have law enforcement to assist if they are available. That they may need to get involved unless we have specific special training in the physical restraint of a patient. And I strongly recommend a formal course from a recognized education group with that specialty of restraint. There's one called MANT, MANT. It is a group that works with psychiatric units and psychiatric nurses. They have a very good program, and if you follow their protocols and if you follow their directions and you do all that, then you have the backing of that organization as well. Going out on your own and doing your own thing and then applying it and somebody gets hurt, you have nobody but yourself to back up with. Always back yourself up. Always cover your own butt. CYA. Over recent decades, several phenomena have been identified that place restraint patients at risk. Excited delirium syndrome is commonly seen in conjunction with abuse of stimulant drugs. Typically presents as a triad of delirium, psychomotor agitation, and psychological excitation. It has been estimated that approximately 8 to 14% of people with excited delirium syndrome die. An associated phenomena is called restraint asphyxia or positional asphyxia. So we need to make sure they are in a position they can breathe and that they are not tied down so tightly that they cannot breathe or they cannot expand their lungs, expand their chest cavity. There is so much involved with this. Some studies indicate that restraint maneuvers may impair respiratory excursion. Other studies indicate that the cause is multifactorial. Positional asphyxia occurs in patients who have used CNS depressants, alcohol, opiates, benzos, and results from the patient being in a physical position that interferes with his airway or ventilation. So they're sitting up and they slump over. They can no longer expand their airway. Their neck is cranked completely forward and closed. Or they're lying face down into a pillow with their mouth and nose covered. They are morbidly obese, and their internal organs, they've fallen or are laying with their head down lower than their abdomen, and all of that is pushing up against, thus restricting the expansion of the chest cavity, teamed up with the slowing or the depression of the respiratory centers within the brain, all lead up to this kind of thing. There has been an increase in negligence suits against EMS and law enforcement personnel related to deaths and injuries that occur during restraint. Paramedics must understand, and ALS providers must understand and practice safe restraint techniques. The use of medications, especially in excited delirium syndrome, can help minimize problems. Always call medical direction. Ask for that assistance. You may have standing orders, but I like having the backup. So paint the picture, describe it to them if you have the time, and get the go ahead. Must understand that medical restraint is high risk and ensure that it is performed safely. For all involved, both the patient and the rescuers, the restrained patient is carefully monitored, and that the circumstances of the call are documented in exquisite detail. Accurate and thorough documentation, again, will save the day. If you are going to chemically restrain a patient and or physically restrain a patient, they need to be completely monitored. They need a heart monitor. They need end-tidal CO2, especially if chemical restraint is used. They need end-tidal CO2 placed, and they need to be monitored that entire time until handoff. And then that report needs to be accurate and concise, and they need to know how much you gave and when you gave it, and so on and so forth. And we just talked about all this already.